all guns are created equal in my mind. But in the eyes of a jury who is not going to be a jury of gun people, some things are easier to explain than others. Pick your battles.
We are the Armed Attorneys. Today we are answering your questions. As always, this is our favorite segment. We're going to be talking about using NFA items in self-defense, suing the cops, and what if you're denied a firearms transfer? How do you get this specific reason from the FBI, and so much more. But before we begin, show your support for the Second Amendment by hitting that like button. And we are so happy to have Emily Taylor back.
I know, finally. Finally.
Leslie did a great job.
Leslie is wonderful, but I'm very happy to be back. And remember, this is where we pull our questions for future videos. So if something's been nagging at you, leave it here. We will, I will say there's at least one that I keep overlooking intentionally because it really only applies to a very, very small segment of people. But for the most part, leave it. We really, really like to answer your questions. As long as it applies to more than like 3 people, we will take it up and answer it at some point. I promise. All right.
So let's get started. The first one is from Terry Banks 2337. This is from a super thanks. This was directed at Leslie, but I'm going to direct it to you.
Sure.
It says, hi, Leslie, regarding your 19-year-old that was arrested for the carry charge. Can you pursue a Section 1983 claim against the agency that arrested the client? If so, what is the likelihood of success? Also, if you were to win such case in federal court, can you spitball the high-low number of dollars? Bad news.
Yeah. No, that it's not a good 1983 claim for multiple reasons.
And I'll fill folks in. So we were talking about, and this is obnoxious, we have in the state of Texas constitutional license carry. We got both of those types. We have a court case that restrains the state of Texas, its officers, agents, and people working in active concert with it from enforcing our prohibition on 18, 19, and 20-year-olds. Those folks should be allowed a constitutional carry, and the Texas Department of Public Safety, they issue licenses to these folks. So
yes.
Clearly, that's the state of the law. As much as some of these, agencies are, they haven't got the memo yet. So we had a client who was arrested for constitutionally carrying.
Mm-hmm.
He was 19 years old, and so the cops not up to speed on the current state of the law. Now, what is a Section 1983 claim? Tell us about that first. And, he was arrested. His rights were violated. Shouldn't he get compensation?
Sure. So a 1983 claim is when you sue the government. You actually sue them in federal court, but you're suing the state government. And you are suing them for a deprivation of your constitutional rights. However, there are lots of issues that come up in 1983 claims and lots that would come up in this particular case. Number one, damages, right? So,
I'd pay a lot of money not to spend a couple of nights in jail.
Sure. But there's not a lot of damages here. We're not talking about lots of medical bills. We're not talking about, we're not talking about a lot of money, which means practically speaking, not a lot of attorneys willing to take this case on in the first place. Number two, let's talk about malice.
Yeah, unfortunately. So when we look at deprivation of rights cases, the right that's being violated has to be clearly established and recognized by law. I think that's our kind of first out for the government here.
Yeah.
Because they're going to say, hey, look, this is kind of a nebulous issue here. Obviously, Second Amendment.
We don't believe it to be, but they're going to argue.
Yeah, well-established constitutional right. This application to 18, 19, and 20-year-olds, this is kind of a breaking area of law. Again, we don't agree with that. So I bet they get out there.
Yeah, and the officer has to make a knowing violation. It's not a malice standard in exactly how it's written, but in its interpretation by the courts, it's essentially a malice standard. Basically the courts are going to look at it and say, did the cop know that he was violating your constitutional rights and do it anyway? And in this case, they're going to be like, nah, man, I was looking at the penal code. It's there's no way to prove that these officers knew that they were engaging in a violation of rights. So
yeah, where that comes up is hiding evidence, arresting, and cops staying on body cams. I didn't, I'm just going to make something up.
Beating the tar out of you.
Planting drugs. All right, we got all these things here. This kind of nebulous, hey, did he not, prove to us that he read this case decision, that he understood the state of, it's just not going to happen.
No, unfortunately. You wish You wish that it would. You hope that it would. Practically speaking, no.
Yeah, and ignorance of the law, we don't
Works
get any.
for some people.
Yeah, we don't get any pass for that.
No.
But apparently the cops get a little bit of a pass.
That they do. All right, we've got one wild turkey. When discussing the SPR deregulation, Leslie mentioned that lots of Leslie shout outs.
Yeah.
Leslie mentioned this deregulation would keep the state authorities from enforcing it. Does that mean state authorities aren't able to enforce federal laws? Are there many federal laws that aren't duplicated in state law? I like this question a lot.
Yeah, so this came up to a pending bill in the Texas House. Call your representative, tell them to support this stuff. HB 259 by Representative Hayes, and this would decriminalize short-barreled firearms under Texas law. Now, the way Texas does it, we define what a short-barreled firearm is. We say generally prohibited unless lawfully registered under the National Firearms Act. And so what does this leave us with? The current state of the law, a lot of police agencies don't really understand what qualifies and what doesn't qualify. Depending on what direction the wind is blowing in DC, Schrodinger's stock, is a brace a stock or not? It's not, we know that. But these guys, they're not getting the memo on this stuff. And so what we have is state actors dubiously enforcing, rules that have been struck down on the federal level. It's just caused all this administrative confusion. We want to scrap all that. All right, if the law changed to where we did not have short-barreled firearms decriminalized, what would that look like from an enforcement perspective on the state level?
Well, the state could not arrest you for having a short-barrel firearm.
Yeah.
And that is, now, this is different from, right? State authorities enforce state law. Federal authorities enforce federal law. The state is not allowed to assist the federal government in 2A matters because we have a sanctuary bill that's passed. However, the state cannot prohibit the federal authorities from coming in and enforcing federal law. So it's good. It means the state authorities are not going to arrest you on a state crime, and the state authorities are not going to arrest you on a federal crime or cooperate with the federal authorities. But it does not mean that the ATF or the FBI could not come in and do that dirty work.
Yeah, so a lawyer, I'm not going to tell you to, break the law, but a lawyer would advise you this is criminal under federal law, not criminal under state law. And then Emily's explanation to it, that would be the state of law in Texas if that repeal were to happen.
Correct.
All right, next one we have is Civilian 76. Have y'all discussed self-defense with NFA items, suppressor, SPR, SBS? I think we have, but it's probably worth talking about.
It's worth talking about. Is it something that will raise an eyebrow with the police or prosecutors? Sure.
Yeah.
Does it really matter that much? I'll tell you that the and I think I've said this on the channel before, the pistol in our bedroom, ready to go on my husband's side of the room in case someone breaks into the house, is in fact suppressed. So
that's the polite thing to do.
Well, do not wake my babies up if you have to kill the intruder is the thing. But so anyway, it doesn't matter enough to me or my family for us to not engage in it. And, the kids obviously I don't want to, scare the tar out of the kids, but also, I would like for my husband to be able to hear the authorities and make a 911 call. And I would not like to be horribly disoriented as I am trying to get to there's all sorts of reasons. So that's our risk benefit analysis.
I would say calculated risk decision. Will a use of an NFA item in self-defense change a good, what would otherwise be considered a justified and good self-defense incident into a bad one? No, I don't think that will happen. Is that something that is going to come up to a jury? Is a jury going to be asking the question, hey, is this unusual? Hey, does this mean that the person is a little bit, kooky? Those are all pretty minor objections, I'd say, that an attorney should be able to at least address, elicit testimony from the police. Police use all these things. Police use short-barreled rifles. Police use suppressors. They all serve legitimate purposes. And so, is it going to be an issue at trial? Yeah, I imagine it's going to come up. Is it going to change a good self-defense incident, defensive incident into a bad one? I don't think so.
I don't think so. And also, choose your battles too. Your suppressed firearm is different than your fully automatic firearm, just as your go-to self-defense weapon in the house, right?
Sure.
In the eyes of a jury. I'm not saying, look, all guns are created equal in my mind, but in the eyes of a jury who is not going to be a jury of gun people, some things are easier to explain than others. Pick your battles.
Yeah, and then the one kind of tag note on that, if you're involved in a self-defense incident with an NFA item, those items get to go sit in custody while this issue is being litigated. You're justified. Guess what? At the end of the day, you get this stuff back. Maybe it takes some time. Maybe it takes years. If you are convicted, let's say it was not justified, well, guess what? This stuff is evidence. You're never getting it back.
Yep.
The other question I think it's worth asking, are you okay with this stuff being held up or tied up for any period of time? For that reason, I tell people don't every day carry your Gucci gun if it's really going to impact your lifestyle.
Right.
Do you care if this NFA item gets tied up? Just something to think about.
It is something to think about. All right, we've got at Blue Roo. How do you make this request for? Okay, so this is, let me just even back up.
Sure.
So we are talking about you get denied a firearms purchase. You can ask the government, not a UPIN, but you can ask them, like, why did I get denied this purchase, right? So, how can you request the reason with your NTN from the FBI? What is the actual procedure? Call, write, email? Richard, how do you query the FBI about your firearm denial?
Yeah, the easiest way is on their website. FBI, seriously, this is as easy as it is. Google FBI firearm transfer denial. You're going to go to their website. It has lots of little acronyms and periods in it, so I'm not going to spell it out for you. But you're providing your NTN number to you. They're going to email you a response saying, hey, guess what? Pursuant to 18 U.S.C. 922 G1, we consider you a felon because of this conviction. They'll tell you the reason why.
Yeah.
And then depending on the reason, the world's your oyster. There's lots of different ways of going about challenging it if it's not legitimate or if they have incorrect information. Or, hey, guess what? I talked to a guy yesterday. The FBI got it right, and they just found an old record that had not been in the system. Bad news. I hate to be the bearer of bad news. But, if they have the correct information, do you really have a remedy? Maybe you get a pardon or something like that. I don't know. But from the FBI, no.
Right.
All right, next one we have is Pew Pew Real Estate. In Texas, can you not carry in a school with an LTC, right? Yeah, this came up. We were just talking about, hey, how does your state define premises, or if they prohibit a location? So this discussion applies to everybody. You need to understand how your state's law handles prohibited locations, whether it's statutory, whether they post signs, if they have a list, and then, within that list, are they saying the grounds are off limits or the property's off limits or the premises off limits? And then are any of those terms defined? So Texas, we have our list of prohibited places, Texas Penal Code 4603, school, premises, generally off limits under that statute. Obviously, there's exceptions to every rule. But when we talk about premise, we mean building or portion of a building. We're not talking about the grounds, streets, sidewalks, breezeways, parking lots, areas around the building. So in Texas, for the most part, when we talk about a prohibited location, we're talking about the building itself.
Correct. And in Texas, if you would like to carry into a school, you need written permission from the highest authority of the school. So just know it's not completely off limits, but that is something that you would need in order to carry inside. Now, that's assuming you're not like a guardian or a marshal or something like that. If you're just Joe Smith. And also, Texas specific, there is a bill that would change that and would let LTC holders carry into the premises of a school. I don't think it's going anywhere, but you can call your state representative and tell them to support HB 4201 by Schatzline, which would do just that.
Yeah, very important. All right, one last one, because we get questions about this from all over the country, even though it's a little bit Texas specific. This one to you, Emily. At B_R, if the Texas passed a new updated sovereign suppressor law, would the current DOJ ATF try to shut it down again? So I think this is a discussion of, and this isn't just Texas specific, if our states are going out pushing back on the federal government, saying, I guess what, we're not going to follow federal law, or we are not going to recognize the federal government's supremacy in this area, do we expect the Trump administration to push back to it?
Yes. So here's the deal, is that all of these suppressor laws across the country, they are all built upon the Commerce Clause. Idea being that if you produce an item that is wholly made within your state, produced with parts that were wholly developed, manufactured, and made in your state, and you never intend to take it outside of your state, you have not invoked the Commerce Clause. Thus, the federal government cannot regulate the item that you have. Now, there is a long line of commerce cases that would say that everything invokes the Commerce Clause, which is ridiculous, but it is what it is at this point. Now, the Trump administration being knock on wood, Second Amendment friendly, would they challenge such a law? Because right now the Texas case is dead as far as I can remember.
Yeah.
So would they challenge such a law? My guess is, I mean, I'm speculating wildly here. My guess is yes, because number one, they're not that pro 2A, but also the federal government does not like people messing around with the Commerce Clause.
Well, and it's because the Commerce Clause is the slippery slope. You know, when the founders wrote the Constitution, they thought, hey, the necessary and proper clause, this thing's going to get abused. Little did they know that it was going to be the Commerce Clause. There's not as much debate about that. But the problem with that is if you invalidate the Commerce Clause or you allow states to legislate themselves around the Commerce Clause, think about every fringe issue that you ideologically don't agree with. Guess what? They're going to drive an 18-wheeler truck full of that issue through the Commerce Clause hole. And maybe we created it with the suppressor issue. So I don't know that it's a genie we want to let out of the bottle.
Yeah, no. The unintended consequences could be massive. So I would imagine that the federal government, even under Trump administration, would still challenge the hell out of that. So,
but I mean, I don't think the federal government should really have. I think they should be really pretty passive, not an active force in our lives. So maybe it wouldn't be that bad of a thing. But I can't see them tolerating that. But
no.
We hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And again, please leave your questions here. This is where we mine for our questions for our next episode. Until next time, we're the Armed Attorneys.